Good evening, this is John Milburn for LAWS12062. This is Alternative Dispute Resolution. We're into week 8 of Term 2 2019. Thank you very much. We have a number of people online. I really appreciate your attendance. And I know that it's always difficult for people to attend online for the sessions during an assessment week. So this week we have our assessment due. I believe that some people have uploaded their assessment work already. Thank you very much for doing so. You can breathe easy now and move on to the second part of the assessment. Now, for many of you, you haven't yet uploaded your work. And one of the things that may be of concern to you is that you're having difficulty in having your colleagues coordinate with you in terms of preparing your work, uploading the work, etc. I understand that from time to time, difficulties do arise. Now, please remember this, that if you're not working together as a team for whatever reason, something's gone wrong, this is an individual assessment. So the idea of working with others is more a convenience support arrangement, certainly not a prescribed requirement of mine. And if you find the need to work with others outside the unit even, then please feel free to do so. So from an individual's perspective, your task is to have the work completed and uploaded by Thursday evening 11:45 p.m. If that means you can't work with others as you had hoped or planned, then so be it. Are there any questions about the first assessment? Anything that people want to share about their experiences? All good?
Yeah, I'd just like to say
Yes,
I know me, Peter, and Remy had a great time doing it. We managed to knock it out in a day, did a couple of dry runs, and then it was just a genuinely good time.
Excellent. Well done. Oh, that's good. So, a good endorsement. Yes, Peter?
I concur.
Thank you. Well, good on you for going through that experience. And what I hope, of course, is as a result of that experience, people create contacts within the course that might assist them in this unit, but also other units as you progress through your degree. So well done. That's excellent. Thank you, Jack. Thank you, Peter. Any other feedback? Any questions?
John, can I ask a question?
Yes, Emma.
Of either yourself or the other students that have done their scenarios yet. If you're doing it online through Zoom and you decide that you need to have a private session, how have they done that? Do you just like cancel one of your participants' videos, or yeah, how does that work?
I've got a response. I'll just see if anyone else wants to make a comment or suggestion. All right, so just bear in mind, of course, it's a mock exercise. So what you can do is mutually agree to turn off microphones and to just pretend, says Paris, that's what they did, which is fine. So you can turn off the video, you can turn off the microphone, and as the mediator, when you're ready to go from one private session to another, all you really need to do is reactivate the video or microphone and just say, please come on in. If the other side hear it, you know, nobody cares. Ideally, you won't, but you can, as Paris suggests, you can just pretend. Does that help answer your question, Emma?
Yeah, that's great. Thanks, everybody.
Okay.
That's really appreciative. We're hoping to do ours tonight, so that's really good.
Oh, well done. All right. Well, thank you even more so for being online this evening. All right. Any other questions? Gary said we just blanked the screen. Yep, very good. Okay, well, good luck with that assessment work, Emma. And please, as has been the case, it would seem, with Paris and Jack and Peter and others, enjoy the process, and I'm sure you will. Okay, so what we're looking at now is a continuation of the discussion that we had commenced last week in relation to a whole range of hybrid alternative dispute resolution procedures, different procedures that have developed to meet different needs and are now being used in creative ways, and also being used in conjunction with each other. So for the second assessment, for the take-home exam, what you need to do is have a good understanding of what these other or additional dispute resolution processes mean, how they're used, what is their statutory or contractual basis, and importantly, how can they be used in a realistic sense to resolve a dispute. So in the past papers, you would have seen situations where I present you with a client or a dispute resolution scenario and invite you to create a plan for something that might work in the future or something that might help to assist the parties currently in a dispute, or it may be a combination of both. So let's start with our discussion about dispute resolution advisors. Would anyone, we've got enough people that I can ask a question, would anyone like to tell me what dispute resolution advisors, they're all, what's all that about? Any thoughts? All right. So dispute resolution advisors are involved in a process. And I guess it's a pretty common theme for dispute resolution. We tend to think about these things as processes. When we discuss dispute resolution advisors, can you tell me if it is generally regarded as something that is interventionist or non-interventionist in nature? Any thoughts? Would you regard dispute resolution advisors as having a role that's relatively formal or informal? We'll see if we can break it down that way. And the reason, of course, that you need to ask yourself these sorts of questions from the outset is that when you receive your brief in terms of constructing an alternate dispute resolution process that might incorporate hybrid systems, your client or clients may give you some indication as to the level of formality that they seek, and it may be that you see advantages in incorporating, at least in part or in whole, a combination of informal or formal components to your system. So Emma said, I would say formal, and they have to have technical expertise. Yes, I agree. They certainly need to have technical skills. But when we talk about informality versus formality from the perspective of ADR practice, I guess what you should consider is the two bookends. So at one bookend, we have the most formal ADR process, the most court-like, to give you a hint. So what would that be? What's the most formal? What's the most?
Arbitration.
Arbitration, exactly. Yes, and Emma's onto that as well. So when we talk about an ADR process that is the most formal, the most interventionalist, the most court-like, we think about arbitration. What's at the very opposite end of ADR practice or process in terms of the level of formality? What is the ADR process that's the least interventionalist?
That'd be mediation, wouldn't it, John?
Mediation's almost in the middle. Almost in the middle. Emma's got the answer I'm looking for. Negotiation. Why negotiation? Well, if we contrast that to arbitration, negotiation is simply two parties essentially trying to sort things out for themselves. It might be as informal as a way of resolving the dispute over a cup of tea or while having a beer. Do you understand what I mean? So it's not involving third parties. It's not involving a formal process that is well documented. Negotiation is a perfectly valid process in ADR, and it's the least interventionalist. We don't even have a third party. So they're the bookends. So when you're looking to determine what is the appropriate procedure, the process, or combination of processes, think about those alternatives. Gary says, have a look at page 151 of the textbook. Yes, very good. I keep coming back to page 3 of the textbook, and you'll recall the sliding scale, which indicates in the bottom left-hand corner that which is most formal, and the top right-hand corner, negotiation, that which is the most informal and the most non-interventionalist. So when you're trying to craft an ADR process for a client where you may incorporate any one of a range of different processes as sub-processes or hybrids of those, because even though there are 14 mentioned in the textbook, there are in fact many more than that. I'll give you one example. In QCAT, we have hybrid hearings. That's not mentioned as one of the 14. And what it means is that we have the hearing of a dispute, and before the member gives a decision, the member turns into a mediator in a purely non-interventionalist model, and having heard all the evidence, the member who's heard the matter and already made a decision, which is written down in a sealed envelope, then attempts to have the parties come to their own decision after the hearing, but before the decision is announced, with a view to them coming up with their own answer to the problem. If they do, the decision written by the member stays in the sealed envelope or is in fact destroyed, never to be seen. If the parties can't come to a resolution, then the member unseals the envelope and says, here's the decision. I will now impose this on you. You see, so it's an extra way of trying to come to a resolution of the dispute, which is not even part of the 14. So if we look at that graph on page 3, you know the one I'm talking about, when we talk about dispute resolution advisors or dispute advisors, you'll see that it's number 3 out of 14. It's pretty much up there with almost negotiation as being a relatively informal way of resolving disputes. Now, it is true that when we involve dispute resolution advisors, we are looking to take advantage of people with technical skills, as Emma had mentioned. So, and Gary raises a really good point. So would the process depend on the type of dispute? Absolutely. And it might depend on the nature of the clientele. It might depend on their wishes. So the great thing about ADR is it is totally flexible, and it's a huge area of potential practice. I think as a growth industry, there will be those people that specialise in ADR in a blanket or umbrella fashion. At the moment, we have ADR practitioners who tend to be mediators or conciliators or arbitrators or dispute resolution advisors, or people that are involved in collaborative law. But I really haven't seen a lot of people that specialise in packaging ADR processes that incorporate the best of all of these elements. So that's the sort of thing that you might consider, and this is where we have a great deal of creativity available to you. So dispute resolution advisors are people with technical skills, and Peter's onto it. Okay, you've read my mind, Peter. So can I invite you to unmute your microphone and let us know some of the background, the history of dispute resolution advisors and how they might be used in a practical sense?
Well, it was very interesting that I found back in the early 1990s, they were building a new hospital in Hong Kong. And what they did was set up a dispute resolution advisory system whereby the all the small matters went to the dispute resolution advisor, and they were dealt with as small matters. And then, so that they never escalated into huge disputes or anything like that. And they were far easier to deal with as small matters. And it ended up that the, I think what they say, it ended up that the whole process was very, very successful, and they ended up with building the Queen Mary Hospital. And there was no large-scale protracted arbitration or anything like that involved in it.
Yes, absolutely. Thank you very much, Peter, for that response, and that's exactly right. So the whole concept of dispute resolution advisors arose out of a need, same as mediation. So you've got two people involved in a building dispute. One says it's red, the other one says it's white. They then can't agree. They immediately turn to the expert, the dispute resolution advisor, the person with technical skills. They say, is it red? Is it white? The advisor says neither, it's green. They look at each other and go, okay, well, it's green, let's get on with it. Do you see what I mean? So as Peter explained, those quick disputes, quick answer from an independent party, not necessarily legally binding on them, but where it can be most beneficial is if the parties agree by contract to accept the decision of this person as an advisor. So even though they may not be happy, it's like, I don't know, footballers in a match, the referee makes a call, they respect the decision and they get on with it. Does that make sense? So you might see the need for that type of mechanism in a practical sense. So the concept began, yes, in Hong Kong. What Peter had mentioned is absolutely correct. The process is that which is relatively informal. We know that. And it involves the parties sitting with the dispute resolution advisor. The object is to attempt to resolve disputes in a quick, efficient, and mutually beneficial way. You may not always be happy with the response, but at least you have a response from an appraiser or a referee, if you like, so you can get on with things. So it's really, the role is, it can be to determine, but strictly the role of the advisor, as the name suggests, is to provide advice rather than to provide a determination. And because the role of the advisor is not to make a determination, then it fits within that category of being relatively informal in terms of a process, as opposed to arbitration or a court system where the role of the third party is to make the decision. All good? So when do you think it would be appropriate to provide advice to a client or clients about engaging a dispute resolution advisor? It's a very broad question, but when do you think that would be? When's the discussion to be had? Yes, Peter.
I would say that that discussion should be had with any large building project for starters, anything that, or large refurbishment project. It's a no-brainer.
Absolutely. And would you say, Peter, that that discussion should be had before the contracts are signed or after the contract?
Definitely before the contracts are signed.
I agree. So if you are consulted by a client who is about to embark on a project, why not consider building in as part of your contract the role of a dispute resolution advisor and appoint the advisor? Have that as part of the agreement. Have a second agreement between the parties to the contract to engage this independent advisor and involve that person in the process as well. Maybe the advisor can be involved in the discussions around what should be included in the contract and have some technical expertise in that regard as well. So the appointment of a dispute resolution advisor can be one-off, as in for this project for a hospital, or it might be on an ongoing, if you like, standing basis. And the idea is that you understand each other in the dispute, you understand the basic facts in the dispute, and you have a resolution before it becomes a full-blown dispute. And people's prejudices and their pride and all those other things kick in. So that's the idea. Yes, Peter. Oh, sorry, okay, thank you. All right, so now, Gary, you mentioned page 151 of the textbook, and at page 151, is there anything that you want to bring to our attention? I don't mean to put you on the spot, but you're welcome to make a comment if you like. All right, so page 151.
Sorry, John, my mic wasn't working.
Yes, Gary. Oh, no, you're right, Gary.
I just think that the figure 5.1 is just an excellent little reference piece. That's why I mentioned page 151. Yeah, that's the one.
John, you're on mute.
Thank you. Sorry, my apologies. So, Gary, thank you very much for raising page 151. And figure 5.1 is a very easy flowchart to follow that shows in very clear manner the sort of way that a dispute resolution advisor can go about resolving a dispute. But of course, you really need, as Peter suggests, you really need to build that into the contract before you start. Peter says, I wonder why governments don't use them on building projects. I think that it's a way of the future, but there is a dynamic, I think, with all of dispute resolution work, ADR, and that is the resistance from the fact that this isn't the way we've done things in the past, so therefore we won't do it in the future. Conversely, this is the way we've done things in the past, so why would we change? So those of us that are embracing ADR, in a way, need to become ambassadors for ADR and be lateral in our thinking. Gary mentions NBN, very good. We'll be talking about NBN shortly, so thank you. And Jack says, would you want to appoint a DRA when there is room for interpretation or ambiguity? That's a good question. Any thoughts on that, Jack? Did you want to elaborate?
Yeah, I would consider that, just in line with what Peter was saying about the Hong Kong experience, that where there's room for sort of interpretation or ambiguity in what the dispute actually is, like you said, you know, one thought it was red, another thought it was yellow, well, it's actually green, where you've got you appoint your expert to provide that little bit of direction and say, no, you guys are both, you know, the old elephant one, the elephant example you point to very early on, that you guys are looking at the same thing from different angles and you're probably not looking holistic.
Excellent point. Thank you very much.
Can I just sort of mention something though too? With the Queen Mary Hospital, this is 29 months into the project. I'm going straight from the book here. They had over 750 variations to the specifications for the project, and there hadn't been one dispute over those variations. So I think where there is a bit of ambiguity, that's probably where it does work well.
Yes. So whatever, and as Jack mentioned, it may be that it's a matter of having consensus on what the facts are, what is the dispute, a bit like mediation where you're trying to find that common ground. What are the true facts that we're arguing about? So when you're thinking about how you might use DRAs, one thing you could do is have a look at the national gas rules. The national gas rules describe the characteristics of the DRA. Have a look at section 135G2 in that regard. So when we're talking about a DNR, sorry, when we're talking about a DRA, then you need someone who has some detailed knowledge, some experience, someone that can work with the parties, you know, in a likable, approachable manner, and really assist. Now, Gary mentioned, it was Gary, yes, the NBN. So let's have a look at the NBN and the Special Access Undertaking. I happen to have it on my screen ready to share, and I'll do that now. So you should see the web page for the NBN Special Access Undertaking, and this was from December 2013. You might want to look at this as a very good example, a very good worked example of how dispute resolution advisors can work in an industry setting. And you'll see there that some commentary in relation to the dispute resolution arrangements that were dated the 3rd of April 2014. You'll find within this document or this web page the approved dispute guidelines. Hopefully that has come up on your screen now, and you can access this material from that web page. So here we have the NBN approved dispute guidelines, and it was prepared by the NBN for the purposes of, and you'll see it there in the introduction, for the purposes of Clause 6 of the SAU dispute management provisions, which are to be applied in a certain manner. Take some time to look at the document. It has some useful precedents. Also, consider the way in which this would have come into effect with general guidelines from the client as to what was needed, but with input from specialists about putting it all together. And you'll see there that it provides for, in Part 3, the dispute management rules provide for the classification by a panel of dispute, and it refers to, in 3.3a, the resolution advisor providing the panel with information on the dispute. So again, it's a hybrid system. Have a look at the dispute management process in terms of panel arbitration. And I'll just attempt to share that screen with you now as well, if I can. Well, actually, I'll just go back to the dispute resolution guidelines. So at the end of that document, you'll see some flow charts. And I really do like flow charts because it helps put the whole process together in a meaningful way. So you'll see there the way in which disputes under the agreement can be resolved by mediation or by expert determination or by panel arbitration in certain circumstances. And all of this is overseen by the dispute resolution advisor. So when I mentioned the hybrid system tailored to meet a particular circumstance, NBN is a great example. And you'll see that the flowchart provides for what happens in circumstances where a dispute arises. And dates, referred to on the right-hand side, provide timeframes, and each party has certain obligations to undertake certain things within periods of time. And all of this is designed to ensure that the process works quickly and is cost effective, so that ultimately everything is done as quickly as possible. All right, so that's something that I'd urge you to look at, and thank you, Gary, for bringing that to our attention. The NBN guidelines, great example if you're looking for dispute resolution advisor work. Let's move on to dispute review boards. So where do dispute review boards sit in the continuum, if you like, of ADR processes? Any thoughts?
A stone's throw from dispute advisors as
Exactly.
a little bit more formal.
A little bit more formal. Yep, next one on the list. So number 4. So number 4, dispute review boards. So dispute review boards are an example of a dispute avoidance process. So you get the idea here that we have, even though we call it alternate dispute resolution, there are 2 broad categories, aren't there? There's dispute avoidance at one end, and there's dispute determination at the other. Now, it's always a bit fluid with these things, but when we talk about dispute advisors, it's primarily dispute avoidance. Dispute review boards, similarly, dispute avoidance process. Again, we normally look at this at a pre-contract level. And once again, we're looking at having someone with technical skills as much as we can on the spot resolution and collective acceptance of problems. So in that sense, the whole philosophy behind the introduction of dispute review boards is similar to the philosophy associated with the introduction of dispute advisors. Can anyone tell me where the process began or how it's affected and used and implemented in Australia? A little bit tougher, this question. Any thoughts? What industry would you expect mostly?
Building.
Say, building again, yes. I'll just pose this question. Do you think that dispute advisors and dispute review boards can only be used in construction? Or do you think that with some imagination, they could be used in a wider range of activities? Bit of a loaded question, really.
I think that they could be used in a lot of activities, really. I think they're not something that you would use in everyday activities, but certainly things that are on a large scale. Yeah, I think they could be so helpful. In fact,
yes.
I could think of about 3 places at the moment where they should have bloody well been used.
Okay, thank you very much. Yep, no, I agree. But certainly dispute review boards, like dispute resolution advisors, most commonly found in the construction industry. And again, the simple idea, keep the lines of communication open, head off potential problems that might lead to a dispute. And the idea of a dispute resolution board is to engage a panel of experts who are appointed to meet regularly throughout the course of a project and resolve disputes as quickly as possible. And usually there are 3 to help with deadlocks. So the review board is more proactive than an advisor who is presumably on an on-call basis. A dispute review board has a role which is similar, but it has a requirement to meet regularly. It has agendas. It has the board of 3, and therefore it's a little bit more formal. Gary says most office environments use them. Yes, okay, very good. And it could save a truckload of hassle, says Peter. I agree with that. So with dispute review boards, there's no binding effect on their decisions. People can incorporate that by contract to make it binding. But usually the disputes are resolved through the dispute review board, resolution board rather, where there's some technical issues. And if you're having 3, probably having a lawyer involved is useful as well. Can anyone tell me if there's a central body that deals with issues around dispute resolution boards in Australia or internationally? Has anyone done some research about dispute resolution boards?
There's the Dispute Resolution Board Foundation. It's a non-profit that's works internationally.
Exactly. That's exactly the one that I had in mind. So thank you very much, Jack. So let's have a look at the website. I'll share the screen once again, and we will try to find it. Sorry. Are you seeing that now? No, I don't think you are. You are, Peter? Is that what you see? All right, so you should hopefully see the Dispute Resolution Board Foundation on the screen, correct? Thank you. So you'll see this was created in 1996. You'll see some background there on the home page. It is, as Jack mentioned, a not-for-profit organisation, and the organisation is dedicated to promoting the avoidance of resolution of contract disputes using the dispute board method. Initially, it was for construction contracts, and historically that's how it's been used. But now, the concept has been recognised as beneficial to, according to the website, any commercial contract with elements of uncertainty and or where the contract work is to be conducted over a considerable period of time. And it goes on from there. So the Dispute Resolution Board Foundation does have members in Australia. So please look at that website. It's very worthwhile. It has some excellent publications, including the manual. And the manual, and it has example provisions as well. So the manual is a practice and procedures manual. You can download that. And if you do have a problem, then you can look at certain contract provisions by way of sample. General articles providing information about how this might be used in a practical sense. So certainly if you have a dispute resolution board issue, look at the foundation website would be my tip for you. Any questions then about that? You happy to do some homework, do some exploring on websites? Okay. Let's have a look at another document, which is the manual. And I'll just share the screen for that purpose now. So again, it's not coming up on my screen, but you should see the DRBF Manual 2007 edition. Is that what you're seeing? Okay, great. And you'll see there, in particular, the user guide and the members guide, and the fact that it's multinational practice. So a very useful document. And again, I like this, full of flow charts and useful information. You might have picked up the hint that if you're involved in the process of drawing some form of ADR process, a platform, having flowcharts is a good idea, and I do like them. So that's a hint. And you might put in timeframes wherever possible, as was the case with the NBN. Right, so I'll just scan through that. It's quite a lengthy document. Take from that what you wish, subject, of course, to copyright issues. And that's an excellent example of how this process might work in practice. All right, well, let's move on. Dispute resolution procedures, and they're referred to in the document. You'll see some diagrams that relate to those dispute resolution procedures, and I'll just bring them up on a Word document where I've copied and pasted them. And this is from the dispute resolution, from the DRBF manual. So I'll just share the screen now. I mentioned earlier that the manual does have some excellent flowcharts and diagrams. So there is an example of one of them. So if the dispute is rejected after a contractor review, which is the one above, then a party may invoke their right to use the DRB. And here are the steps associated with doing so. And you'll see that that diagram is drawn from the Chartered Institute of Arbitrators Dispute Board rules. And it goes on to provide for the fundamental canons of ethics of the Dispute Resolution Board Foundation. And that is in section 2, chapter 10 of the documentation. All right, I'll stop the share, but I do invite you to look through that for yourself and draw material that you think would be relevant to your future work and the assessment. So we have the dispute review boards and the website there. Now, the next one is partnering. And by now, of course, you get the idea that you simply to look at the continuum or the sliding scale, and partnering is way up near negotiation. So this is, once again, a dispute avoidance process. It's less formal than the dispute advisor or the dispute review board process. Can anyone tell me, in a nutshell, the difference between partnering and dispute advisors or dispute review boards? Is there a simple way of categorizing the difference between them? Well, perhaps I could help by saying that it's clearly less formal. We know that. And one way of thinking of it is partnering is a form of do-it-yourself dispute advisors or dispute review board process. Once again, the idea is that it's aimed at avoidance rather than resolution, and it's often considered at a pre-contract level. The idea is that parties take advantage of in-house advisors with technical skills, and one of the best ways to consider partnering is to think about it being conducted in the with the concept of a charter in mind. Now, the charter is, for want of a better term, a sophisticated handshake. It's not binding, but in the event of a dispute arising, by adopting the principles of partnering and having prearranged a charter, the parties will always refer back to the charter when it comes to attempting to resolve the dispute. The idea of the charter, the idea of partnering, is so that the parties adopt a cooperative culture of mutual trust and respect. Sorry. One of the hallmarks of partnering is the way in which the parties at a pre-contract level think about, excuse me a moment. Sorry, tickle. Often gets me at this time of night after talking all day. The idea of partnering is the charter. That's a good hallmark for it. You've heard of mission statements. So it's sort of like a mission statement. The charter sets out the ground rules for communication, and it sets out a way in which to review and reinforce the charter and the process. I think my voice is telling me that I've talked enough for tonight, so I'm sorry. I'll probably have to cut it short, but I'll just see how I go. So again, partnering, background in the construction industry. It can work beyond construction, And it's particularly useful if there's a degree of complexity in relationships. So if you have multi-parties, if there's a potential for breakdown in communication, if that's part of your brief, to ensure that the lines of communication are always kept open and there's some structure, there's some common ground as to how we communicate with each other, then I think partnering, probably in conjunction with other forms of ADR, should be something foremost in your mind. So what it means is that you're inviting the parties to work on collective goals, and the idea is to change the mindset from the parties competing with each other to foster their individual goals, to work on a team approach to the problem. In other words, remove the them and us and replace it with we. That's the idea of partnering. It sounds a bit airy-fairy, but it's really powerful if done well. And I guess collectively, in a commercial sense, there is the mutual ambition to ensure the job is done well, makes a profit, it's done quickly and cheaply, but effectively and safely. So all of these things can be incorporated into partnering. And the idea is that you create a situation where people work together. Now, what are some of the things that you would need to foster for people to work together well in terms of partnering? What are some, maybe if I could just ask you to think about some of the words or phrases that come to mind that would help to emphasize this team approach and encourage parties through partnering to work cooperatively. Are there any words or phrases that immediately come to mind?
There's no I in team.
Yes, that's a good one. Not sure you'd incorporate that into your document, but yes, that's a good. Emma's come up with some others as well. Trust and communication. Yep. Any others? So things like the ability to work together, to be flexible, to be open, honest, transparent, things of that nature. So if you're putting together a partnering document, you probably want to actually use some of these phrases, maybe even Peter's phrase, but something along those lines so that people get a clear idea of what it's all about. Then we have case appraisal, expert determination, and early neutral evaluation. What I might do is leave it at that for this evening, but start with, oh, and Peter says aims and objectives. Thank you very much. So next week, what we'll do is we'll start with case appraisal, expert determination, and early neutral evaluation. I'd like you to have a clear idea during this week as to what each of those terms, what each of those processes means individually, but importantly, what do they mean together? What are the differences between them as well as the similarities? And how could you possibly incorporate these processes into an overall ADR package? All right, so we'll leave you with that homework. But before I go, are there any questions, any comments?
I've got a question, John, but it doesn't relate to what it actually relates to the assessment.
No, you absolutely, that's fine.
I'm blonde. I forgot to put my scenario, attach my scenario. I've just put can I just email it to you?
You can just email it to me, that's fine.
Okay,
because the scenario is really for my information.
Yeah.
It's not really part of the assessment.
No, I had embedded the video into the opening statement.
Yep.
Document, but forgot to do the scenario.
I understand. No, just by all means, just send that to me.
Okay, thanks.
My email, that's good. So thank you for asking that. Any other questions, comments? We all good? All right. Thank you very much. So when you're undertaking your reading, please do so actively and do so creatively, thinking, how can I use this in a practical sense both for the assessment and in practice if this is an area of practice into the future. All right, all the best, and we'll see you next week. Bye then.
Good night, John.
Bye.